Welcome back to the Deep Dive. You're trying to keep up with the world. You're reading modern constitutional law, perhaps reviewing some history.
Right, you're trying to connect the dots.
Exactly. And then suddenly you realize that the most urgent legal issues of today, they were already solved, or at least fiercely debated, 14 centuries ago.
It's that feeling of information overload, isn't it, where history seems completely disconnected from the present.
It is. And that's exactly what we're tackling today.
Precisely. Our mission really is to provide a kind of shortcut to that historical and legal understanding.
A shortcut is a good way to put it.
We're taking 3 points in time, separated by, immense cultural and chronological distances.
We're talking 7th century Medina, 1960s Arizona, and contemporary Pakistan.
And we're going to show that they are not disparate at all. In fact, they are unified by one singular, crucial legal thread.
Our sources for this, and they're drawn from some extensive research by constitutional and corporate lawyer Mr. Zahir Ahmad Mir, they zero in on 3 very specific legal benchmarks.
Benchmarks concerning the rights of the accused.
Right. First, the foundational judicial ethics, established by Caliph Umar ibn al-Khattab. Then, the iconic U.S. Supreme Court ruling, Miranda v. Arizona in 1966.
And finally, the really robust constitutional safeguards detailed in Pakistan's Article 10.
And the underlying philosophical question, the deep dive we are taking today, it's profound.
It really is. It boils down to this. When and why do legal systems decide to create explicit protections for the citizen from the state itself?
That's the key distinction, isn't it? We aren't talking about protection from crime.
No, not at all. This is about protection from arbitrary executive power. The police, the investigators, the administrators. This is where true liberty lies.
And the most incredible part, for me, is seeing the functional equivalence of the solutions. You have a system rooted in early Islamic jurisprudence, one in the U.S. common law tradition, and then a modern system that sort of combines both.
And yet the safeguards they build against abuse are almost perfectly mirrored.
It's like we're searching for this universal human realization that, unchecked authority is the greatest threat to justice.
Well, what's fascinating here is that this shared understanding confirms that the rule of law, it isn't a cultural artifact.
It's a necessity.
It is a necessity for an ordered society. When human beings gain power over the liberty of others, the same abuses surface, and therefore the same ethical and procedural constraints have to be applied, regardless of the era.
Okay, so let's unpack this timeline. Where do we start?
We have to start at the beginning.
Okay, let's establish the scene. We're in the 7th century, roughly 634 to 644 CE. This is the Caliphate of Umar ibn al-Khattab.
Yes, and the sources paint a really vivid picture of rapid expansion.
Which means the centralized state had to quickly develop effective but also controlled instruments of power.
That is the crucial context. Under Umar, the Islamic State was evolving, and fast. It went from a decentralized community framework into a sophisticated, structured government.
So what did that look like on the ground?
The sources note the establishment of formalized institutions. You have dedicated courts with judges, or qadis. You have an administrative hierarchy, regulated markets, and most importantly for our topic, an early police structure known as the shurta.
And whenever you formalize power and then you delegate it, you create bureaucracy.
And the risk of abuse skyrockets.
Right. Power is no longer solely in the hands of the ruler. It's in the hands of regional governors, street officials.
People who might be tempted to misuse it. So the question becomes, how did Umar respond to this inherent risk of delegated authority?
And the answer is pretty striking.
He responded by erecting an immediate and very high legal barrier. The sources are definitive on this. He issued one of the earliest and most forceful global edicts specifically against arbitrary arrests.
And this wasn't just like a suggestion or a piece of advice.
No, not at all. It was a mandatory legal requirement for all officials, everywhere, across the entire caliphate.
So what was the core ruling he established? What was the letter of the law?
It was simple, it was absolute, and frankly, revolutionary for its time. He said, no person shall be arrested except with clear evidence.
Just stop there for a second. If you look at that through a historical lens, that single ruling fundamentally redefines the relationship between the ruler and the ruled.
It does. It means the executive branch, the police, the administrators, they must justify their actions with verifiable facts before they can touch a person's liberty.
Let's spend a moment on that term, clear evidence. In a pre-modern legal system, what exactly did that mean, and why was it such an enormous hurdle to clear?
It's a great question. It required bayina, which means objective, verifiable proof.
So not just a feeling or a rumor.
Absolutely not. It often meant multiple credible eyewitnesses or discovered facts that were beyond dispute. What it specifically excluded was zan, which is mere conjecture, or shak, which is suspicion.
So he's drawing a very bright line.
A very bright line. And this requirement wasn't just, administrative policy. It reflected a deep ethical commitment to the presumption of innocence.
And the difficulty in obtaining this kind of hard evidence, it would naturally restrain the rapid, unchecked use of police authority.
That was the goal. So if the shorta, the early police, were tasked with maintaining order, this ruling means they could not, say, arrest someone just because they were known to be a troublemaker.
Or because a rival pointed a finger at them.
Exactly. Or based on a private enemy's accusation. They had to have the hard proof right then and there.
And Umar made this explicit. He didn't leave it to interpretation.
Not at all. He prohibited the use of suspicion entirely. His direct orders to his governors and regional officials included the directive: do not imprison people merely on suspicion.
That's so direct. It cuts off the most common tool of arbitrary power.
It does, because suspicion is subjective. Anyone can be suspicious, but clear evidence is objective. He insisted that the legitimacy of the state depended on its adherence to this high objective standard.
And he coupled this legal restraint with an ethical warning, didn't he? Linking the law directly to moral accountability.
He did. He told them, fear Allah in the matter of the people.
Which is,
Yeah.
that's the genius of the system.
It is. It frames the rule of law not just as pragmatic statecraft, but as an inescapable ethical duty.
So an official who arbitrarily arrests someone isn't just violating policy.
They're violating a sacred trust. And this gives the rule immense moral weight. It provides an internal check on the conscience of the official, which complements the external legal checks.
But let's introduce a little friction here. I mean, the caliphate was expanding, it was consolidating power. Requiring clear evidence must have, at times, hampered the police force's ability to respond quickly to threats.
Of course. Political unrest, security issues.
So how did Umar balance that need for security with this rigorous demand for individual liberty?
That is the constant tension of governance, isn't it? But the sources show that Umar deliberately, consciously tilted the balance toward liberty.
So he was willing to accept a certain level of risk?
He accepted that some crimes might go unpunished temporarily, rather than opening the door to the systemic injustice of arbitrary detention. For him, the injustice of a state official overreaching their authority was a greater threat to the legitimacy of the state than the risk posed by an ordinary criminal.
So security has to be achieved within the framework of justice.
Not by subverting it. His stance was exactly that.
And we have that incredible anecdote that illustrates his personal, almost furious commitment to this principle.
Yes.
Tell us about the incident where an official arrested a man based only on an accusation of theft.
This anecdote is foundational because it shows the implementation of the rule, not just the rule itself.
The enforcement.
The enforcement. An official who either misunderstood or just willfully ignored the standard arrested a man based purely on suspicion. He assumed guilt. He didn't demand proof.
And when Umar found out.
His reaction was instantaneous and profound. He confronted the officer.
And the quote is just. It's stunning, he said. Had I the power, I would punish you for imprisoning a Muslim without evidence.
And that quote is so much more than just a reprimand. By saying, I would punish you, Umar established that arbitrary arrest is a punishable offense.
Committed by the state official.
Exactly, against the individual. In that moment, he elevates the arbitrary deprivation of liberty to an official crime, requiring accountability. This is the definition of a sovereign holding the executive branch criminally liable for its overreach.
That concept, that the ruler holds himself and his agents accountable, that is precisely what defines a just system. So, okay, let's synthesize these specific edicts and reactions. The research identifies 4 foundational legal principles that were established 14 centuries ago.
These 4 points are really the blueprint for modern due process.
Let's start with the cause of the restriction. What's number 1?
Number 1. Arrest must be lawful and justified. This is the clear evidence rule. It mandates that every single action taken by the police must have a legitimate factual basis. It's meant to prevent arrests based on political rivalry, personal bias, or just plain fear.
Okay. Number 2 addresses the time in custody.
Detention must be minimal and strictly accountable. Now, there wasn't a codified 24-hour limit like we see today, but the principle was crystal clear. Detention was a necessary evil, not a punishment.
And it couldn't be indefinite.
Absolutely not. The official responsible for the detention had to be prepared to justify the necessity and the duration of that custody. This prevented the use of jail as a tool of repression or intimidation.
Right. And the accused must know why they're being held.
That's number 3, the right to be informed of charges. If your liberty is curtailed, the state owes you an immediate explanation. You can't be held in the dark.
Which prevents secret indictments.
And it allows the individual, or their family and community, to start preparing a defense. Without knowing the charge, defense is impossible. It's a non-starter.
Okay, and finally, what about the treatment of the person while they're in custody?
Number 4, the right to defend oneself and receive humane treatment in custody. This is the core principle of dignity.
So even the accused retains their full human rights.
Absolutely. This mandate directly prohibits torture, abuse, or any kind of pressure intended to extract a confession. The state's obligation to humanity does not cease when a person is arrested.
It is truly remarkable how comprehensive that framework is. It addresses the cause, the duration, the fairness of the proceedings, and the dignity of the person.
It sets a standard for ethical governance that, you're right, would not be formally matched in many Western legal systems for over a millennium.
Okay, so with that ethical benchmark set, let's fast forward 13 centuries and shift continents. We needed to see how the exact same problem reemerged in a completely different context.
Yeah.
So we now jump to the mid-20th century United States.
Yeah.
And the challenge here is slightly different.
It is. The rules for arrest, what we now call probable cause, were generally established. The legal blind spot had shifted.
So what happened after the arrest?
Yes, to the custodial interrogation.
Yeah.
But the fundamental threat remained the same. State power exploiting the vulnerability of an isolated accused person.
The Miranda case is a perfect example of this. It shows how a highly developed legal system, one that even has constitutional guarantees for rights, can still allow procedural gaps that lead to systemic injustice.
That's a great way to put it. The focus shifts from the police making an arbitrary arrest out on the street to the police using coercive methods inside the station.
So let's detail the specifics. We're talking about Ernesto Miranda's arrest in 1963 in Arizona.
Right. Miranda was arrested in connection with a very serious crime, kidnapping and rape. He's taken into custody, and he's interrogated for 2 hours straight by Phoenix police officers.
And the crucial point.
The crucial point is that at no point prior to or during this lengthy interrogation was he told he had the right to remain silent, nor was he told he had the right to an attorney.
He eventually signed a written confession.
He did, and it even included a boilerplate acknowledgement at the top saying he was aware of his rights.
But the reality on the ground was very different.
Completely. He was not an educated man, he was vulnerable, and he was completely isolated. The source highlights that the police were employing what were then very common psychological tactics.
Let's talk about those tactics.
Yeah.
Because this wasn't about physical abuse anymore.
No, the Supreme Court was very much aware of the interrogation techniques that were prevalent at the time. They were often codified in police manuals, like the famous ones by Imbaugh and Reed.
And these techniques moved away from brute physical force.
And towards sophisticated psychological manipulation. They relied on isolation, on minimizing the crime, pretending to have overwhelming evidence, or even feigning sympathy to get the suspect to just talk it out.
These are techniques designed to break a suspect down.
To coerce a statement. And they rely almost entirely on the suspect's complete ignorance of their legal footing.
So the court recognized that the environment of a custodial interrogation is inherently coercive.
That's the key legal insight. When a person is deprived of liberty, isolated from any outside support, and faced with professional interrogators,
the constitutional protection against self-incrimination, the Fifth Amendment, is effectively meaningless.
It is, unless the accused is made fully aware that they have the power to stop the questioning.
So the question before the U.S. Supreme Court wasn't really about Miranda's guilt or innocence. It was about the confession.
Exactly. Was the confession used to convict him truly voluntary under the Constitution?
And the court, in its landmark 1966 ruling, said what?
It said it was not voluntary, because the inherent coercion of the environment had been exploited by the police. The ruling essentially said, if the government wants to use a confession, it must first prove that the accused was truly operating from a position of informed consent and free will, not from a position of vulnerability.
Okay, this is where we should probably clarify the technical legal balance the court achieved.
Right.
Because the ruling connected two different amendments, right? The Fifth and the Sixth.
Yes, and this is a really clever legal move. The Fifth Amendment is the right against compelled self-incrimination. You don't have to testify against yourself.
And the sixth is the right to a lawyer.
Right, the right to counsel. In an ordinary court setting, these are distinct, but the Miranda ruling essentially merged them in the context of the interrogation room.
How so?
The court reasoned that to protect the Fifth Amendment right to silence, the accused must have the immediate ability to exercise their Sixth Amendment right to counsel.
Because the lawyer is the only reliable buffer against that coercive environment.
That's it. So the lawyer is the external mechanism required to make the internal right to silence functionally real.
And this led to that mandatory prophylactic safeguard.
The court held, the individual must be warned that he has the right to remain silent and to have an attorney. And if that warning isn't given, or if the suspect indicates they want a lawyer,
the interrogation must stop.
Period.
This mandated requirement gave birth to the famous mandatory phrasing known globally as the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you.
And that specific phrasing is designed to instantly neutralize the power differential. It puts the government's limitations and the individual's power on the table right at the outset.
And if the police fail to administer this warning upon taking someone into custody, the legal consequence is severe.
Extremely severe.
Let's talk about that consequence. It's encapsulated in the doctrine known as fruit of the poisonous tree. This concept is often mentioned, but can you explain what it functionally means in this context?
I can. It means that the failure to read the warning, that initial procedural contamination, it taints all subsequent evidence that's derived from that failure.
So it's not just the confession itself that's inadmissible.
No, it goes much further. If the suspect, without being Mirandized, confesses and says, "I buried the weapon in the park," the police cannot then go to the park, retrieve the weapon, and use that weapon as evidence.
Because they would never have found the weapon but for the illegally obtained statement.
Precisely. The initial illegal act, failing to read the warning and proceeding with the interrogation, that poisoned the tree. The weapon is the fruit of that poisonous tree.
And this severe consequence is what ensures compliance by law enforcement.
It has to be severe. It reinforces the ethical mandate that the state must follow due process, otherwise its entire case risks collapsing.
What's remarkable is the philosophical continuity here. The Miranda decision, even though it's separated by 1,300 years, adheres perfectly to the ethical core established by Umar.
It's the exact same shared philosophy. Umar insisted on bayina, or clear evidence, before taking liberty.
And Miranda insists on informed consent before the state can use a person's own words against them.
Both systems mandate that power must not exploit the vulnerability of the accused. Both are checks on the executive's most tempting shortcut: arbitrary power or coerced evidence.
It just demonstrates that the impulse to preserve human dignity against the machinery of the state is a universal feature of systems that strive for justice.
It has to.
Okay, so we've established the historical foundation and the procedural requirement. Let's now move to a modern constitutional codification of these very same principles. We transition now to Pakistan, a modern state whose legal history. It's a fascinating blend. It integrates both British common law principles and deeply rooted Islamic legal ethics.
It does. And Article 10 of the Constitution, which is titled Safeguards as to Arrest and Detention, represents a contemporary codification of everything we've been discussing.
It's comprehensive.
Yeah.
And it's a powerful statement because it takes these ethical constraints, the need for evidence, the need for counsel, the limit on duration.
And it elevates them to the highest law of the land. It makes them mandatory and, crucially, judicially enforceable.
Okay, let's break down the 6 comprehensive safeguards listed in Article 10, and we can highlight how they echo the historical principles we've traced.
Let's do it. The foundational point, which mirrors Umar's edict perfectly, is the principle that no arrest except by law.
So no executive whim.
0. This ensures that every action taken by the police is traceable to specific legislation or established procedure. It's a formal rejection of arbitrary action.
Okay, secondly, addressing the need for immediate transparency, we have the right to be informed of the specific grounds of arrest.
This is so vital. Like the 7th century requirement, it ensures the accused can immediately begin to challenge the basis of their detention. The charge can't be vague or generalized. It has to be done promptly.
And the 3rd safeguard addresses that power dynamic during detention, the need for an external buffer against coercion.
which is the right to consult and be defended by a lawyer of choice. This is the constitutional implementation of the Miranda principle. The state must provide access to legal counsel, guaranteeing the person is not negotiating their liberty alone against the state.
Right. Now, perhaps the most immediate procedural check on police power. The clock starts ticking with the mandatory production before a magistrate within 24 hours.
This is the critical mechanism of judicial control. The 24-hour rule is a modern-day, highly specific implementation of that old principle that detention must be minimal and accountable.
So the police can't just hold someone to interrogate them indefinitely.
They cannot. After 24 hours, the detention ceases to be a purely administrative act and it becomes a judicial act.
So what specifically happens during that magisterial review? Why is that 24-hour limit so powerful in practice?
It forces the executive branch, the police, to immediately present the arrested person before a judicial officer, a magistrate.
Okay.
And that magistrate must review the initial arrest documents and determine if the police actually have sufficient grounds, probable cause, clear evidence to continue holding the person.
And if they don't?
If the evidence is lacking, the magistrate must order their release. If the police need more time, they have to formally request a remand, which the magistrate can either grant or deny based only on necessity and evidence.
So this process prevents those fishing expeditions police might use if they were given limitless time.
Precisely. It keeps the executive on a very short leash.
Okay, fifth, the constitutional guarantee of guaranteed habeas corpus rights.
This is the ultimate check. Habeas corpus, the right to demand that a court review the legality of one's detention, is the citizen's final shield against unlawful imprisonment.
So if an individual is being detained arbitrarily or secretly or without due process,
their lawyer or their family can petition the High Court or the Supreme Court, which must then compel the state to produce the person and justify the detention. This single mechanism enforces all the other 5 rights.
And finally, there's an overarching rule.
A general protection. General protection against unlawful detention.
Which acts as a kind of constitutional safety net.
It does, ensuring that no technical loophole can be exploited by the executive to deprive someone of liberty. It reinforces that freedom is the norm, and any deviation must be legally justified down to the letter.
It's so clear that Article 10 synthesizes the lessons of the past. It directly reflects Umar's principles.
Yeah.
No arrest without proof, immediate notice of the charge, and judicial oversight of detention.
Absolutely. The modern constitutional language confirms the enduring validity of that 7th century ethic. But, codifying rights is only half the battle.
The other half is the judiciary's willingness to enforce them.
To enforce them against the state, especially during times of political tension.
And this brings us to the significance of judicial reaffirmation in Pakistan, specifically citing Supreme Court judgments like Benazir Bhutto v. Federation of Pakistan in 1988.
And the Asfan Yar Wali case in 2001.
Why are these cases so important?
These cases are vital because the court didn't just recite Article 10, they actively used it to push back against the state's encroachment on liberty, often in highly charged political environments. The Benazir Bhutto case, for instance, involved challenges to the use of preventive detention laws against political opponents.
And what was the Supreme Court's definitive conclusion in these rulings? What was the principle they laid down?
The courts established unequivocally that personal liberty is the most sacred constitutional right.
Most sacred. That's powerful language.
It is. By using that term, the judiciary placed liberty at the very pinnacle of the constitutional hierarchy. This means that laws allowing for preventive detention, or any actions taken by the police, must be interpreted narrowly and viewed with profound judicial suspicion.
So, if the government tries to use security concerns or political necessity to bypass the 24-hour rule or the right to counsel,
the Supreme Court has set a precedent that any such encroachment will be judged against this most sacred standard.
So it mandates that constitutional rights are not conditional upon the executive's convenience.
Exactly. The courts essentially took the ethical constraint established by Umar that detention must be accountable and armed it with the full force of constitutional precedent. They ensured that officials in 20th and 21st century Pakistan remained just as accountable as the official Umar threatened to punish centuries before.
This whole journey just confirms that the defense of liberty requires constant vigilance and robust legal enforcement, transcending historical periods and cultural origins.
It's a continuous process of ensuring the state adheres to its own foundational rules.
Okay, so let's synthesize all 3 of these traditions now and draw our final unified conclusions. This really is the core aha moment of the deep dive. We've analyzed the ethical framework of a caliphate, the procedural fix of a U.S. Supreme Court ruling, and the constitutional text of a modern republic.
Right.
So now let's bring all the sources together in a structured comparison. Let's highlight the functional equivalence across all that time and geography.
And the sources show that the specific language changes, but the necessary legal function remains identical. It confirms the universality of these safeguards.
Okay, let's look first at the standard required to take away someone's liberty, the initial barrier to arrest.
In the 7th century, Umar demanded clear evidence, bayyina.
And in modern U.S. and Pakistani law, that translates to probable cause.
Right. And the terminology differs slightly. Clear evidence has a more concrete ring to it, while probable cause implies a reasonable likelihood.
But functionally, they do the same thing.
They do. Both standards reject subjective suspicion, or ZAN. They mandate that the arresting officer must be able to articulate objective facts that would lead a reasonable person to believe a crime was committed.
Okay, next, the conduct within custody. Specifically, interrogation fairness. Umar required no interrogation without fairness as protecting the person's dignity and their ability to mount a defense.
And this is perfectly reflected in the Miranda standard, right to silence in counsel.
So fairness in the 7th century relied on the ethical constraints placed on officials.
While fairness in the 20th century relies on the procedural requirement that the state must actively inform the accused of their right to resist the state's efforts to incriminate them. But both recognize the inherent unfairness of that power dynamic.
Let's talk about accountability and dignity. The Islamic tradition stressed that the state must protect dignity even of the accused. What is the functional implementation of that ethical command in modern law?
It is codified in Article 10, the safeguards against abuse of police powers. The 24-hour rule, the access to counsel, the right to notification. These procedural rules are the practical safeguards against rough treatment, undue pressure, and secret detentions.
So they protect the dignity of the person.
By using procedural constraints, you prevent abuse. You ensure officials cannot just disappear a person into the system.
And finally, the accountability of the ruling power itself. Umar established the principle that the ruler is accountable for wrongful detention.
Today, we enforce this through judicial review of unlawful arrests and detentions, specifically through habeas corpus petitions.
So the executive branch is no longer punished by the Caliph directly,
but by the judicial branch invalidating its actions and releasing the detained person. The courts step in as the check, ensuring that executive power is constrained by law, not by whim.
It is truly remarkable. These three systems, born of vastly different legal and theological traditions, all converge on the exact same set of required protections.
This unified table really does provide the strongest argument for the universality of due process.
And this convergence leads directly to the single central legal maxim, the ratio decidendi, as they say, the core principle that the research identifies as uniting these legal traditions across 14 centuries.
It's the central thread.
So what is the revelation?
It is this unwavering declaration. Liberty is the default state of a human being. It may only be restricted through due process, not executive whim.
Liberty is the default state. That is a phrase just loaded with legal and philosophical weight.
It is.
It means freedom is inherent. It doesn't require justification. It flips the entire burden of proof onto the state.
Precisely. If liberty is the default, then the state is forced into an exceptional position whenever it seeks to restrict it.
And that restriction must be justified through due process,
which is the standardized, public, and legally established method. If that process is violated, if the official acts on whim or suspicion or coercion, then the arrest is void and the default state of liberty must be restored immediately.
This principle is what links Umar's fury at that arbitrary official with the Supreme Court's insistence on the Miranda warning.
Yes. Both are fighting against the state substituting its own arbitrary will for the rule of law.
So if we review the broader consequences of adopting this principle globally, it becomes so clear why these safeguards are essential for a just society.
They're non-negotiable.
Firstly, the sources summarize that recognizing this principle means accepting that arbitrary arrest destroys justice.
A society that allows arbitrary arrests simply cannot claim to be just. It creates systemic fear, it silences dissent, and it makes citizens servants of the state, rather than the other way around.
Secondly, it enforces the crucial political tenet that police power must be limited.
Limited police power is the signature of a free society. The moment police power becomes absolute, the rule of law dissolves into rule by force. These safeguards are the formal chains placed upon that power.
And critically, it ensures that human dignity must be protected, regardless of the accusation.
Even if the accused is guilty of the most heinous crime, the state's process must remain dignified and humane. That protection is what separates a civilized legal system from a system of vengeance.
The functional result of Miranda is that confession must be voluntary.
Yes. Voluntariness is the measure of the confession's validity. If the state must coerce the words lose their legal meaning. This ensures that the state actually investigates crimes rather than just extracting statements.
And finally, the ultimate goal.
Freedom must be the norm, detention the exception.
That is the philosophical conclusion. We start with liberty, and we only move to detention when the state has fulfilled every single procedural and evidentiary hurdle mandated by the rule of law.
A powerful historical insight.
It truly is. It illustrates that Islamic legal ethics provided a robust and detailed blueprint for due process that aligns perfectly with modern constitutional safeguards, often preceding them by centuries. It's a testament to the enduring human need for checks on power.
And the practical application of this knowledge for you, the listener, is the ability to recognize when these fundamental processes are being followed or violated in any legal system anywhere in the world. You now have the framework to see it.
This has been an incredible journey, tracing the legal concept of protection from arbitrary power across time and culture, thanks to the deep insights provided by Mr. Zahir Ahmad Mir's comprehensive research on comparative judicial ethics.
The unity of legal thought across Medina, Washington, and Islamabad is undeniable.
It is compelling, and it provides an essential lesson in legal history. And finally, we want to leave you with the core moral implication derived from this entire deep dive, the metric by which we can truly measure a society's commitment to justice.
A society's freedom is not measured by its wealth or its armies, nor by the severity of its penalties, but by how it treats the weakest person in its custody, and whether it upholds the absolute sanctity of their liberty. That is the constant test of governance.